No, I disagree, my lord. I'm sitting with a statement from Brigadier Ninava right in front of me, and I can read it to the court. He is from the policy, the head policy in the component governance, legislation and policy in the Division of Legal Services of the South African Police. He made this statement, and there's no authority, there's no section or standing order that he says this. I can read the statement into the docket. So if I'm being told there is an authority, I don't know where it's coming from, because this brigadier is from the policy division of the South African Police, and he says there's no policy that prescribes a specific form. It's a statement under oath signed by him, my lord, and it was, as I said, it was done last year.
This is my time to cross-examine. If there's a need for whatever information that you have that the state feels needs to be placed on record, they will still have an opportunity in re-exam to place that information on record.
No, my lord, that may be true, but I cannot agree to an assertion that is not correct. When I'm being told I'm wrong when I say there is no prescribed policy or standing order that says a specific form must be used. How do I agree with that when I know it's not correct? I'm sitting with a statement of the custodian of the policy. He stated clearly he's the custodian of the standing orders in the South African Police, and he says, and he's a brigadier for that matter, there is no prescribed form in the warning statement. How do I agree with the assertion that is put to me? And I'm being told now, because I'm under cross-examination, that will be wrong of me to agree to that.
Brigadier, you have just said that what I put to you is incorrect. When I say you are incorrect, and you are saying to me, no, you are correct. In other words, when I say to you, you are incorrect, I am incorrect myself. But the reading of that information that you have, that will be in the domain of the state. Remember, I'm not here representing the state. Do you understand? And there's a procedure here at court. Unfortunately, within the context of the South African Police Services, that says that that prescribed, there's no specific form that is prescribed by the South African Police Services, a form that should be used when a suspect statement is taken. I'm saying in that regard, you are wrong. And allow me to proceed with my line of cross-examination.
Well, technically, Gininda, you brought this upon yourself. Okay, you brought this upon yourself. I don't know how many times you have been told. Advocate Mshololo told you, just answer the question, be brief to the point, stick to what I asked. Nisi has been telling you, and you guys are on cross-examination 2.0 extended version. This is the 4K version, okay? We're getting it in 4K version. Because Brigadier Nicholas Bongani Gininda just listens to no one in his lifetime, okay? And he's gone over there to the head policy component government legislation and policy division of the legal services of SAPS and found another brigadier, okay? You know, it's when it's brigadier to brigadier, and he says, listen, we don't know in what context he had with the brigadier. That brigadier has to come in, okay? I'm not saying he's wrong. I'm saying we don't know what context it is, and if he's going to write a statement, he must come to court and answer questions, because we can't just be out here accepting statements. But if we're a law, unless this is a lawless society, okay, where Brigadier Gininda sits in his tiny little corner making his tiny little rules, and every police station is doing whatever they want, then are you surprised at the crime rate we are currently experiencing? But I don't want to digress. Now, I was saying, Nisi is not wrong. See, you triggered him. You're just rambling and talking endlessly like this is the National Commissioner's Office. This is not the National Commissioner's Office. This is the High Court, where Nisi is an authority. You might both be officers of the court, but Nisi is actually an advocate. I don't know if you get what I'm saying. So he asked the question, you answered briefly, and specifically with regards to the question, not force down Mnisi's throat a document that you brought that nobody asked you, because I remember yesterday nobody asked you to bring it. Mnisi didn't ask for them. Again, you're doing that thing again. Like when you ran around looking for Dr. Mbatsane, but you know what? I don't wanna go there, okay? Now, Nisi, Mzansi was not wrong. Drop a 1 in the comment section if you think Mzansi was wrong. I don't think Mzansi was wrong, and here is why. He specifically asked him a question. Brigadier Kinenda went up, down, left, right, center, and and it can only be so much patience that you can exercise. So Mzansi tells him, listen, bro, that's not how it operates in the court of law. If you have some extended addendums that you want to add, not a problem. Bring them up in re-examination with the state, because you guys are buddies as state employees. I don't work for the state. Allow me to proceed with my cross-examination, because you are wrong. You are wrong. And we'll find out later why Mzansi was not stuttering when he said Brigadier Kinenda was wrong. Even in an extension, also this extended brigadier from the policy department is also wrong. It means something is not working in the SAPS department, but let's stay tuned. We'll definitely find out. I think it's video 3 coming up, but stay tuned, okay? This is your opportunity, if you're not subscribed, to turn on those notifications, because we're still going to break down this battle of the giants in the Pretoria North High Court. I don't know if you guys have heard the saying that when 2 elephants fight, it's actually the grass that suffers. And direct translation of that is that the 5 accused, Brigadier Kinenda and Mzansi, get to go home at the end of the day. They get to continue living their lives. Mzansi gets to go to church. Kinenda gets to continue studying for his LLB. I mean, there's a lot that goes on. But most importantly, the grass is the one that suffers. The 5 accused are still implicated in this crime. They're still the prime suspects. They are charged with the murder of SENZO MEYIWA. SENZO MEYIWA's family, also represented in the grass analogy I'm giving, are also impacted, because while these two are fighting and there's a battle of the giants, SENZO MEYIWA's family still has not received justice. So, yeah, that's my commentary with regards to that. Let me know your thoughts. Let's continue listening on. If Brigadier Kinenda was interested in the justice for SENZO MEYIWA, why would he be so driven to just be so belittling and demeaning to the defense every single time, especially when he says, I've already dealt with that? But we're not there. Let's continue listening on. I'll be back with the rest of my commentary.
My lord, yes, the advocate Mzansi can proceed, but I can't agree that I'm wrong when what I know, supported by the custodian of the standing orders, agrees with me. How do I say I'm wrong? Unless then I must refer to the state, to that authority. I don't know where it's coming from, because the statement before me comes from the custodian, a brigadier in the policy section of the police, and he says there is no prescribed form when you take a warning statement prescribed by the police. Says there's no such policy. How could I agree with what I'm being told, my lord?
Thank you. When you say you don't agree with me, I'm not saying you should agree with me.
Sorry, Mr. Minister.
Maintain your position.
We're still going to go around. Can I have that document?
Yes, my lord, you may.
Because you're arguing about documents which you have, which I don't have. Can I have that document? Because you're talking about documents which were handed over. Sorry. Did you hand over this document to
the state advocate, my lord? That was last year.
Does the defense have it? Hello?
I'm just trying to...
Mr. Ramsepiri, do you have the document?
I can't
to remember if...
Okay, you'll have it.
Yeah.
I want to follow the argument.
My colleague says we did give them. We can mark it exhibit ZZ.
No, fine, I'll just read.
3.
I'll just... Because it also has what it calls an SAPM. But I'll just read what he claims to be the policy.
This is the relevant.
No. I want this one, which was being quoted by the brigadier. Yeah, this is the one you're quoting, eh?
Yes, my lord. It's just that it is an attachment that
Yeah, I see. That's why I'm saying it is attached to this statement regarding interview with a suspect, yes, which is called SAP 3M.
Yes, that's the one we're debating before court, my lord.
No, he's not debating that. Affidavit in terms of section...
Sorry, my lord, as the court pleases.
Yeah,
Maybe I need to bring the following to the attention of the court.
yeah,
Remember, the court is an arbiter.
yes.
Now, when the court reads that document into record, there might be instances where the person who wrote that document, there are instances where that person who wrote that document may be required to come and testify.
Yeah, no problem. No problem. If you want him to come, no problem. I will issue the subpoena for you.
Now, what I'm saying, my lord, is let that document rather be read into record by the person who...
No.
Thank you, my lord.
You are saying there is no policy. You. He says he can't agree with you
No, my lord.
because there is a policy.
No, I am saying,
Yes,
he is saying there is no policy.
that's it. And you are saying
And I am saying to
He's
him,
wrong.
he is wrong.
that's it. So,
Yes.
as an arbiter, I'm
Yes.
taking the two composite assertions, okay? And I'm entitled to do that
Yes,
because you can't agree.
we'll never agree because
Okay,
it's
fine.
cross-examination, my lord.
Affidavit in terms of section
Yes.
234 of the Criminal Procedure Act. Can you just read section 234 for us?
Pertains to official documents.
Yeah, just read it so that we all are on the same page.
Proof of official documents. Section 234, subsection 1.
Right?
It shall, at criminal proceedings, be sufficient to prove an original official document which is in the custody or under the control of any state official by virtue of his office, if a copy thereof or an extract thereof, certified as a true copy or extract by the head of the department concerned or by any state official authorized thereto by such head, is produced in evidence at such proceedings.
Yeah, fine.
Subsection 2, paragraph A. An original official document referred to in subsection 1, other than the record of judicial proceedings,
Right?
may be produced at criminal proceedings only upon the order of the Attorney General. Then paragraph B, it shall not be necessary for the head of the department concerned to appear in person to produce an original document under paragraph A, but such document may be produced by any person authorized thereto by such head. Then subsection 3, any official who under subsection 1 certifies any copy or extract as true, knowing that such copy or extract is false, shall be guilty of an offense and liable on conviction to imprisonment for a period not exceeding 2 years.
Okay, fine. That's enough for the purposes of this court. This is said to be an affidavit in terms of section 234 of the Criminal Procedure Acts 1977. Peter Willem Ninabar states under oath in English, I am an adult male with ID number. He mentions the ID number. I'm 55 years old, employed as section head policy in the component governance legislation and policy in the division legal services of the South African Police Services, SAPS, holding the rank of a brigadier, and he mentions his telephone number. My duties at Legal Services inter alia include the following: drafting and maintenance of delegation documents, drafting of national instructions and revising of standing orders, maintenance of the database, version control and safekeeping of policies, national instructions and standing orders, and drafting of legal opinions for the management of the South African Police. I am the custodian of all policy, national instructions and standing orders in the SAPS. On the 26th of November 2024, Brigadier Keninda made inquiries regarding policy or directives of the South African Police dealing with the South African Police 3M statement regarding interview with a suspect, also commonly known as warning statement, I indicated that I could not find a policy or directive of the South African Police specifically dealing with the completion of the SAPA 3MM form attached as PWN, the one which is attached here. Paragraph 5.1 of the National Instruction 6 of 2014, that is the prevention and combating of torture of persons, attached as PNWN2, inter alia deals with the interviewing of persons in custody and provides as follows. Every member must follow the following instructions when interviewing a person in custody. 1. Before the commencement of the interview of a person in custody who has been arrested for alleged commission of an offense, members conducting the interview must identify themselves and inform the person in a language he or she understands, A, of the offense in respect of which he or she will be interviewed, B, of his or her rights to consult with a legal practitioner of his or her choice, or should he or she prefer to apply to be provided with the services of a legal practitioner by the state, C, that he or she has the right to remain silent and that anything he or she says may be used as evidence in a court of law, and D, of his or her right to apply to be released on bail. From the SAPS 3MM, Form SAPS 3MM contains instructions relating to the use and completion of the form. These instructions need to be followed when completing the form. It is my prayer that this Honorable Court take judicial notice of the above. I know and understand the contents of the statement, and I have no objection to taking the oath, and it is signed on the 17th of November 2024 at 10:15 by Brigadier the Camper. He is the authority who certified this. Can you give this also a citation? Yeah, you can continue, sir, if you want to continue.
The exhibits ZZ in brackets 1 in brackets B.
Once again, the two huge elephants in the room could not reach an agreement or agree to disagree. Judge Rutter takes a decision to enter the arena, and not only does he enter the arena, he decides to take a look at the document in dispute, the affidavit from Brigadier Ninabar, I think they said it is, who is the head of policy in Tontoni's over there at the South African Police Services in the Component Government Legislation and Policy Department. Okay, Division of Legal Service from South African Police Services. Okay. We hear you, sir. He looks like he's in the right place to ask the questions that Mnisi has with this regard. Judge Rutter then takes an executive decision, and he decides that he is going to read and he decides that he is therefore going to read the document into the record. And in so doing, in listening to the document, for me, it makes sense. I have no further questions based on what it says. The document literally says, I couldn't find a policy. So I believe at this point, it would have been in Mnisi's best interest or his client's best interest that to acknowledge that, one, Gininda is not the right person to proceed to answer any further questions with regards to the warning statement, because Gininda is going to die. This is the hill that he's willing to die on. Okay, it's the hill he's willing to die on. Mnisi cannot change his mind, and remember, it's the hill he is willing to die on. So in the interest of justice, because this is why we're all gathered in that courtroom, the interest of justice for the deceased SENZO MEYIWA, okay, not male egos, the interest of justice and the 5 accused in terms of their judgment, which, sounds like it's already done, but you know what, Asikolapo, basically it would have been in Mnisi's best interest to call Mr. Brigadier policymaker over there onto the stand to answer the questions further. That is the directive I would have done, or the application he should have done, because speaking to Kinenda about this any further is a waste of time, especially taxpayer revenue, because Kinenda is just going to keep going around in that circle of his. You know, Kinenda is like a hamster, okay? He's like a hamster on the wheel, and he's just going to keep going round and round and round and round, hey, no matter what. I don't know his family lifestyle. I don't know who is at home with him. I don't know who, if after court he went to the office. I bet you after that he was still talking about this warning statement and still talking about how the order of events and still talking, because that's what he is. That's who he is. He needs to talk forever and ever and ever. But so, yeah, let me know your thoughts with regards to that. That's my opinion. I would love to hear what you think about it. Yeah, Mr. Brigadier Policymaker should have been called to the stand. Yeah, that would what I would have done. I still stand by that. I'm going to end this video here, okay? Because we can only do these in bite size. Okay? It's too much to listen to these two endlessly. I'm going to end it right here. Thanks for watching. You know the house rules. Like, comment, subscribe. If you've made it this far in the video, you absolutely have my heart. Thanks for watching all the ads. Thanks for not skipping the ads, guys. I really appreciate it. And I see it in my analytics. Yes, I do see it. It has an impact. When you hit that skip button, it impacts my revenue. And you guys know I take my time to do these videos for you because I absolutely love it. I'm also going to drop my Facebook link in the comment section down below. Come over there and say a big hello, because we're venturing into Facebook land. Yeah, we're venturing into Facebook land. The content there is going to be slightly different, so possibly, yeah, I'll let you guys know once it's all set up, but I need you guys over there. Hit that follow button and let's work together. Thanks so much for watching. I absolutely love it. Those watching from outside the club, the fact that you're still watching is shocking to me. 45% of people that watch my videos are not subscribed. You know what? That number used to be 61. So you know what? I'm happy. You guys are taking your time in making the decision. Let's do it, because we're on the road to 100,000 subscribers. Thanks for watching. I'll catch you in my next upload.